position that based on the merger with the underlying felonies and the felony murder, that would be a case that you are would not be able, that would merge and would not be able to sentence separately.
Okay. Does the defense intend to introduce any evidence in mitigation?
We're going to argue, and then Ms. Driver is also going to speak.
Okay. All right. Ms. Gropper, if you'd like to present the victim impact statement, please.
Yes, Your Honor. Can you turn on the monitors, please?
What this is.
Thank you, Your Honor. And would it be acceptable for him to deliver that from the podium?
I would prefer the witness stand,
Okay.
please.
All right. Come on.
He doesn't need to bring anything up.
She wants you to leave everything.
You need to leave it back there, sir.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. You can have a
If you
seat.
will move the microphone,
Yes.
please.
You can have
Is it okay to stand to present?
You have to talk into the microphone, so it'd be better to sit so we can hear you.
A lot
Please
of
sit,
work.
sir.
Is it forbidden to stand?
Can you state your name?
Benyamin Ben-Michaeil.
Okay. And can you spell that?
B as in boy, E as in Edward, N as in Nancy, Y as in yellow, A as in apple, M as in Mary, I as in igloo, N as in Nancy. B as in boy, E as in Edward, N as in Nancy, hyphen, M as in Mary, I as in igloo, C as in cat, H as in hotel, A as in apple, E as in Edward, I as in igloo, L as in Lucy. Eliyahu, I left out.
That's
E as
fine.
in Edward, L as in Lucy, I as in igloo, Y as in yellow, A as in apple, H as in Harry, U as in useless.
Can you tell us what your relationship was to the victim in this case?
The victim was my daughter,
Okay.
Hannah Nicole Driver Ben-Michaeil.
Okay. All right. And Mr. Benyamin, I want you to, or Mr. Ben-Michaeil, I want you to tell the judge about what Hannah was like in life.
645 days ago, I had the most beautiful living daughter on Monday, the 5th of December, 2020. She was dressed in a tiny, prescient little pea coat that was also colored pea, curry yellow. We were at a rest stop in McDowell, North Carolina, and I brought her toward her favorite thing, the arbors, in the middle of the rest stop where the grass was green, and the trees were tall and the roots were old and ripped up. I like to call her Naima, which means pleasantness, and she was pleasant to all she came and encountered. The most pleasant.
What was her disposition and demeanor like?
Well, we stood at that tree. She counted every layer of the roots. She was 13 months old. She had had a penchant for trees since she was a month and a half year old. She was sweet. There are babies that are planned. We know what the opposite of that is. But then there are babies that are planned. This child was deliberate, intentional, and the mental work of 2.5+ years prior to her 9.5 months in utero and her entrance into this world. There are a very special sister with 3 babies. And by the last one, Eliana, we came up with a term. There are forward-facing babies and not forward-facing babies. I have an older daughter who's estranged, you've heard about here, named Eiley. She was not a forward-facing baby. Eiley cared about mommy and daddy. You put her head in your armpit and you were wherever you were, and that was not Hannah Nicole. Hannah Nicole was a forward-facing baby, meaning when you carried the baby, she needed to see everybody and smile at them, everybody in the room, as if she almost had an innate nature of knowing that she had very limited time. She had to see everything, and she'd get really, she'd let you know that she needed to be turned around if you were not holding her face forward-facing babies. My sister's little Eliana was like that. I learned to hold her that way. She wanted to be taken around. She wanted to count everything. And she was looking at those roots that day in her little coat, and she had her little curls that came over her hair. And that's my last really strong, close memory of holding my daughter, playing in those roots of those trees. Her disposition was just the sweetest baby. And I'm not saying that as biased dad. I've been around a lot of children. She was different. It's like she was hosting everybody she met. We would run. I wanted to bring the little Legos. We would run. We would play. By the time she was 13 months old, she had a real thing for little cars. We'd chase them around the room together. I'd crawl with her. Beautiful. She was really weird looking. And some babies have this and some babies don't. Between like 4 months and 7 months, they're like growing. Some things are growing too fast. Some things are growing too slow. But by 13 months old, she was so beautiful.
Did you provide photographs that you'd like to
I would like to, please. Yes, Katie.
see of Hannah?
Please.
Your Honor,
Please, the court.
I'm going to publish the photographs that,
This is me and Hannah together.
and approximately how long prior to her death was this photo taken?
About a few months. This is at a really beautiful, inexpensive hotel room in Clinton, Connecticut, and they have massive floor space for a hotel room like this. And we were chasing those little cars around all day, these little rev-up cars. So this would be the second week of August of 2020 when we were down with my family, as will be depicted more clearly in better photos coming. And my brother-in-law, Nathaniel Lewis, and my sister and her 3 children were all here meeting their cousin. This is in May of 2020. This is the quartz sand of Siesta Key, Sarasota. And we were spending a lot of time there. We were spending time at Nokomis, in Venice Beach, the adjacent smaller beaches, and we would come in her wagon. And you can see what she's doing. See, she was not a passive baby. She would grab the handle of the wagon and look at me like it was the most fun thing to get and smile at Daddy at Dover, just to smile into my eyes and say, look, I'm leading the wagon. She'd do it every day. She'd take hold of the handle and say, I steer this. This is my wagon. And this is in Clinton, Connecticut again. And you can see, if you want to see her nature, that's her nature. That's her nature.
Was she a happy baby?
She was excited and happy and engaging, and she'd come up to you and want to just learn everything. She'd want to touch you and smile. She'd want to get inside you and let you know that you should be happy too. Grandma threw a tennis ball a little too fast. What? Yeah, that's a picture from a little bit of the weirder period, where some of the eyes are growing, things are growing a little too fast and out of line. And I know this is the preferred thumbnail for the court, but that was when she was looking a little silly. So that was probably back at about April of 2020. This is my parents' living room, where she would come up to this piano over here, and she had a knack, and she would start. I'd be playing piano. I've been playing piano since I was 3 years old, and I would ensconce her and encompass her in all my music, and she would come in the middle, near the middle C, and she would start doing things that actually made sense. And then she'd look at you, and she'd show you she could have a beat. My older daughter, Eiley, has an immense amount of musical talent, but she could never keep a beat, but she would come up with things. But Naima, Hannah Nicole, she could tell where the beat was. She knew where the beat of life was. She knew where to enter the room. She knew where to look at you. She knew where the camera was.
And are those the cars that you spoke she enjoyed playing with?
No, these are very little cars that you'd pull and they'd zoom around the room. This is actually a toy that I had going back to when I was a child, and it has a revolver inside, like a revolving scoop, and it goes around, and it's funny, it like collects toys into its dump truck. This is a xylophone that was my sister's over here. Little cup. She rode that little Poo-mobile behind her everywhere in my parents' house, and she was amazing because sometimes as a mother you wanted to sleep a little bit more. Chloe would go over, Coo would go over, and she would open the bedroom door and lay back down, and she'd thunder down the hallway. She'd just crawl down because we had this whole area on the second floor, safe, the dogs in the kitchen, the stairs over here blocked, and she had this living room up the hallway to the bedrooms, and you'd hear her, my mom still imagines the beauty of her grandchild thundering down the hallway, crawling thunderously. She'd come and she'd play, and my Eiley couldn't leave her for 3 minutes, even when she was 12, 11 months old. Constant attention, not Hannah Nicole. Hannah Nicole, she got in the living room with her stuff. She'd make a story. You could leave her playing there for 20 minutes. She'd make up a world. She'd put the dolls. She had things that 11 months old, 13 months old, she'd be piling cars. She'd be making a whole story and happily playing. And somebody comes, smile, go over, pet the dogs. This was her world. Everything here, Grandma made the entire house her world. That's why we were there.
Sir, the purpose of this hearing today is to give the court an understanding of sort of the impact of the actions of
Nobody can weigh the potential of the impact. When you lose Grandma and you lose Grandpa and you were not estranged, you have a life, a rich life lived. You have memories. It's painful. It's a natural process and cycle of life. When you lose a baby, and somebody entitles themselves by whatever precipitation, you can get into the moral philosophy if it is okay or not okay. Do you own your life? Can you take your life? But when you entitle yourself by whatever precipitations, by whatever precipitated your mind, without getting into the weeds, to decide you are entitled to take somebody else's life based on your opinion of whatever kind of mental illness, lack of mental illness, acting, pretending you're in mental illness, overlaying, masking, it doesn't matter. There is no wiggle room where you are entitled to take somebody else's life because of your impression or opinion. They are there to live life and discover what life is for themselves. The impact of losing Hannah Nicole, driver Ben-Michaeil, cannot be measured. We sat around in the waves of some luxurious beach somewhere for 2.5 years, speaking tenderly to each other, dreaming our daughter. Before she was born, buying her the highest level, best things, doting on her. Nobody knows. Deanna doesn't know. Jeff doesn't know. Your Honor, you don't know. Nobody knows. She could have grown up and given humanity cures to things we don't even have diseases for yet. How can you measure the potential? How can you look at a father and say, the image I have of a 5-year-old, of a kindergartner, I lost the potential, I lost the view. The most unplanned child, to the most unprepared parents, is a travesty and a tragedy of the highest order that the parents may never be able to even articulate the pain and loss of. Now you're talking about a baby who was not just planned, but planned. A baby who was meant to put their best foot forward. A baby who was taught to have a moral and cultural consciousness that would give to humanity whatever she could possibly find as her niche and knack in the world. To measure the impact and loss privately, I'm a very hard individual. I've lived a very particular life in countries that are not here to get knowledge and find things. I'm not a good model for initial reactions. In other words, I'm extremely stoic. That doesn't mean there wasn't 13 months after, and every private moment when I screeched like a frightened 7-year-old girl, where I sat for 3 months in a van just screaming and screaming and screaming that this woman believed that she was entitled to take my daughter's life out of this world because she stopped believing in having a moral consciousness and the duty to help humanity, because she believed the girls who were with us, not that she didn't believe in polygyny, she didn't believe in the girls who were with us, she believed they were reprobate, second class. She believed she put in more energy and people did not reciprocate to her, and she quit around June 3rd, 2020, and planned Hannah's death because she planned to exit the world and take her daughter with her. She may have even abused her and felt that there was some issue on a phone call between taking the girls to Connecticut when she said, "If you don't get your ass back down here to the South as quickly as you possibly can, I will throw this baby on the floor because I'm tired of her screaming and I can't get her to go to sleep the way you do," which was a beautiful segue that I love spending time with my daughter, putting her to sleep. It was like my job to put her against my heart. We spent lots of time rocking and going into sleep, and Chloe just had triggers from being raped and abused as a child, suffocated and jumped on by a drunken Eric driver who caused her to be triggered by sleep. And she doesn't even know it herself. I apologize. I'm very emotional.
I understand, but the purpose of this hearing is about Hannah and the loss of Hannah and the impact.
And this is the impact on me.
Can you tell the court whether you have any feelings with regard to punishment or sentencing?
Nothing that actually happened to her would ever change her. I don't know that no sentence, maximum sentence, could ever get through to her in a way that she won't build a new identity, a new mask, change who she is, manipulate the next party. Chloe Alexis Driver wasn't a victim. She had the most power in our group. It was called her fits. I don't know what kind of a sentence would help her. I mean, the inclination to say death penalty, maximum. She believed she could take the life of a baby out of this world, a baby, any baby, and this beautiful baby who had this much potential to help the world, an impact that can't be weighed. Nearly unlimited potential. Can we see the others?
Photos?
Yeah. There's a whole nother email with the ones with the family.
These are the ones that I have.
She didn't send that.
All right. Your Honor, I have nothing further.
Ms. Tretheway.
For an argument.
I have no questions of this witness.
You can step down.
Thank you.
Any other evidence from the state?
Just proper an argument, Your Honor. I'll reserve.
All right. Ms. Tretheway.
Judge, I just want to be clear, and from what we've talked about, the entire 4 years that this case has been pending, what we talked about at trial, what we're here to talk about again today, is that Chloe Driver has never once disputed the events that occurred on December the 8th of 2020. We've always all agreed that this was nothing short of a tragedy. She's never denied or disputed that she killed Hannah. Never been any dispute either, but it seems to be falling on the wayside that Chloe also stabbed herself in the neck 5 times and once in the chest to try to kill herself based on her mental illness. From the very beginning, this case has always been about Chloe's mental state at the time of the crime. That's it. It has always been about a young 17-year-old, then 20, naive individual with pre-existing mental health issues, involved in an abusive, both physically, mentally, by a man more than twice her age. It has always been about years of abuse, coercive control, and living in this cult mentality that only exacerbated these mental illness. It is clear from the evidence that came before this court by both the state and the defense that clearly showed that Ms. Driver was suffering from severe mental illness at the time of the crime, that she suffered from the delusions that overwhelmed her and told her repeatedly for months that she needed to kill herself. There has been a documented history of mental illness in her teenage years and prior to the incident that occurred. We also heard about eyewitness testimony from individuals that were with her and experienced her during this time about her conditions and her subsequent deterioration. And that she had been asking for help and communicating this to those immediately around her because she was just getting worse and worse. During the trial, it may not have appeared at first glance, to the court or to the jury that this case was about Hannah. It's always been about Hannah. We never disputed what happened with Hannah. But the only issue we were here to decide was to talk about Chloe's mental health. She's always acknowledged that what her actions were, but it is also about Chloe. As Your Honor is aware, I have been involved in this case since the day that Chloe was discharged from the hospital. I met her on December 22nd of 2020 in the book-in area of the jail on suicide watch in a turtle suit in a room where I had to speak to her through a mail slot. She had nothing in her room. She had but a mat and a styrofoam cup for water. At that time, she was still suffering from her severe self-inflicted injuries, still suffering from her ongoing psychotic episodes, and grieving over the death of her daughter. Over the last 4 years, I have had the opportunity to watch Chloe not only battle her mental health demons and try to grieve and properly observe everything that had happened, but I've also noticed that she has also grown up and matured. I have watched Chloe grieve for 4 years over the loss of her child at her own hands, but also endure the loss of her own family, physically and emotionally, both her mom and dad, and any of the life that she had before December the 8th. There has never been a time since I've been involved in this case that Chloe has ever said, I am not responsible for what happened, or any attempt to deflect that. This case has always been about mental health and her mental state leading up to the event. It has never been about blaming anyone else for Hannah's death, but simply an explanation to how Chloe got to this point. It has always been about seeking justice for Hannah and for Chloe, asking the state to take all of this into consideration in resolving this case. As Your Honor is aware, we worked extensively with the state for years in an attempt to work out this case based on the facts and the circumstances and the extent of the mental health issues. And also in an attempt to explain exactly what Chloe, along with other individuals, have endured in a relationship with Mr. Ben-Michaeil. We ask for consideration of those very facts and not to treat Chloe just as any other criminal defendant charged with the crimes. That was what we were asking of the state. Ms. Driver sat down with the state, provided a substantial amount of information in an interview to the state in an attempt to explain everything that had happened to her. This past Sunday was exactly 4 years from the incident. Monday was exactly 4 years to the date that her parents found out what happened to their daughter and granddaughter. Mr. and Mrs. Driver had originally indicated that they wanted to speak on behalf of their daughter today. But every year at this time, the events of what happened on December 8th of 2020 hits them especially hard. They do support their daughter. Ms. Driver came to trial and indicated what she observed and what she felt. So we don't want this court to feel because they are not here today that they don't care, they don't support her. This is just an especially hard set of scenario and facts, but also around the time of the anniversary of the incident. There has not been a single day that goes by where Chloe does not think about Hannah, that she does not regret what she did, and would do anything to go back to that time and change everything. There's not a day where Chloe doesn't think about how this affected the very people she loved, and especially Hannah, the one person she knows she was supposed to protect. There is not a day that goes by where she does not wonder what her daughter would be like now at the age of 5, or what her life would look like if she had managed to get away from this cult
and treat her mental health issues, which is what her parents had begged her to do. Chloe is, and always has been, remorseful for her actions. She takes responsibility for her actions and has had 4 years to be able to see and have insight now that she is medicated and diagnosed and away from that relationship. We are asking this court to consider everything we presented at trial and the hearings leading up to trial. We are asking this court to recognize, as the jurors did, that this was never a case in which Chloe did this crime to have Benyamin to herself. It has never been a case about selfishness or anything else like that with respect to the relationship. This case was always about being a severely mentally ill woman with significant trauma that fought and fought against her own mind until she was no longer able to do so. We heard testimony from all the experts and the witnesses about her deterioration in the months leading up to this. We heard about her behavior and the delusions from those who interacted with her during that time. This was never a situation where she was feigning or faking mental illness. 3 experts told us that. Witnesses told us that. There were evidence that she was experiencing these overwhelming psychotic symptoms and delusional compulsions, and that this was something that she fought every day and was very real. There was significant evidence that showed she acted in ways that showed she was losing her mind. She communicated that to the people who supposedly loved her. We all remember the testimony of Jason Spillers. We all remember his testimony about her behavior. We also know he told us how much she loved Hannah and that she would never have done anything to harm Hannah in her right mind. We are asking this court to remember the witnesses that told us how much Chloe loved her child and did everything she could to be a good mother and take care of her daughter, all while struggling with the undiagnosed and untreated mental health issues, all while struggling with emotional and physical abuse at the hands of Benyamin Ben-Michaeil and being subjected to this cult indoctrination that alienated her sense of being, her sense of self-worth, and any semblance of independence. But more importantly, it alienated her from those who genuinely loved her and who loved Hannah, her parents. Her parents were the only ones in this whole scenario that didn't view Chloe or Hannah as property. All of this combined led up to what happened on December the 8th, 2020. I'm not going to rehash everything that this court and the jury heard in this case about the 3 different experts, but all 3 experts throughout the pendency of this case have all told us about the significant depths of Chloe's mental illness. All of which agree that she suffers from very significant, severe mental illness. All of these diagnoses require significant treatment, not just medication. All of the experts told us that these illnesses require actual treatment and medication, and they just don't go away. As Your Honor is well aware, that Chloe has been incarcerated since her release from Kennestone Hospital. She was 20 years old at the time. She is now 24. Since the beginning of incarceration, she has not received any type of mental health treatment aside from medication regimens, which is constantly in flux and changing, even to this day. She has absolutely no criminal history whatsoever. We are asking the court to recognize, based on her age and lack of history, that there is opportunity for her to not only deal with these mental health issues, but become a better person and serve her sentence and still be a productive member of society, all at the same time in justice for Hannah. We are asking this court to sentence her to life with the possibility of parole. Chloe intends to utilize her time in custody in the Department of Corrections to continue her religious exploration, her education or vocational or college training, and better herself. She intends to continue to assess what she needs for mental health purposes and is going to continue to take medication so that she doesn't fall back into her previous ways. When I first met Chloe, all she wanted to do was die. She continued to express severe concerns that she would still try to actively harm herself and that she didn't want to live anymore. 4 years later, every day is still a challenge while on medication, but it is something that she is facing head on. She understands that she doesn't need to take those desperate actions, that there are reasons for her to live, and those reasons include being there for him. As Your Honor is aware, life with the possibility of parole requires her to serve 30 years at a minimum in custody prior to being considered for parole. At that point in time, she will be approximately 50 years old, and potentially without the physical presence of her parents due to their age. It is something that Chloe is cognizant of, but also understands the importance of accepting her punishment. She has always said that she has no issue with whatever happens, and she will respect the decision of the court. And she understands that there needs to be a punishment for what happened. She regrets this every day. She may not outwardly express it on phone calls, chirps, text messages. But over the last 4 years, there have been hundreds of phone calls, hundreds of text messages, hundreds of visits with myself and Mr. Kessler, all of which Chloe discusses what happened and is remorseful, is upset, is crying. Your Honor saw Chloe during trial, during the pictures of Hannah, and during testimony. You saw her reaction to it today. She is remorseful. She is not without remorse and upset about what happened. She beats herself up about it every single day. She tries to talk with her parents about Hannah in a positive light to keep her memory alive, and wonders what would happen if she had just done something different. Justice for Hannah in this case includes a sentence of life with the possibility of parole. That takes into consideration all the things the court needs to consider in terms of rehabilitation, punishment, and deterrence. She can be treated, while likely with only medication, in the Department of Corrections, but there are other opportunities for her to avail herself, to rehabilitate herself. And we are asking the court to give her that chance. And we are asking that you sentence her to life with the possibility of parole.
I'll let the state argue, and then I'll hear from the driver.
All right, thank you.
Your Honor, first I'd like to address, I don't know that it's necessary, but in response to Ms. Trethewey and her commentary about trying to work this case out with the state prior to trial. The state has always offered the minimum sentence on murder, which was life with the possibility of parole. The state extended a plea offer for her to plead guilty but mentally ill to life with the possibility of parole. That was our plea offer and has been our plea offer for a very long time. The law does not permit the state to deviate from a life sentence for murder, and that was the minimum sentence that could have been offered, and that was what the state offered in anticipation of trying to resolve this case to spare everyone the trauma and burden of having to go through this trial. That was an offer that Ms. Driver chose to reject. Secondly, Your Honor, I would like to remind the court of sort of what we saw in the pendency of this case. Ironically, most of the emotional impact of the consequences of her actions came from people who didn't even know Hannah. came from people in this community who had to respond to the consequences and gravity of her actions. We saw police officers, grown men, who silently wiped their tears from that witness stand as they had to relive that child dying in their arms. We saw grown police officers clearing their throats to try to maintain their professionalism and composure as they had to relive the weight and gravity of what she did. We saw the jurors openly weep for that child as they had to watch that body cam video of her life slipping away and had to watch the autopsy photographs of that baby and the manner in which she was slaughtered by her mother. We watched those people weep and have a visceral reaction to having to see that child in that way. And that was something that was done by Chloe Driver. Ms. Trethewey indicated that this was because of her mental health, but the undisputed fact is she's not in that condition now. She's in above average intelligence. She's perfectly competent. She's medicated. She's receiving care. Ms. Trethewey stood before you and said she regrets this every day of her life, and she doesn't necessarily openly express it in her chirps or in her phone calls. And I suspect what she's referencing are the chirps that the state served on the defense that she was sending during the course of her trial. During the course of her trial, where the rest of us were dealing with the burden and the weight of having to advocate on behalf of that child, she's going back to the jail every night and having phone sex with her boyfriend, talking about what size penis she likes, how she likes rough sex, how she wants to be treated like a rag doll, how she wants someone to ejaculate in her mouth. We are all having to watch people fall to pieces over that baby in this courtroom. And she goes back to the jail and can't wait to have phone sex. It demonstrates what we know, which is a complete calloused indifference for the life of this child. The one person who should care about her. What is very clear is that Hannah Nicole Driver, at 13 months old, she could experience fear, she could experience pain, and she knew that that was her mother. And in the last moments of her life, that's what she got to experience. Panic. Fear, pain, and panic, as a knife was repeatedly plunged into her body. And the fact that the woman responsible for that action, in the condition she's in today, can go back to the jail after watching her child in that condition and send chirps such as, "I'm stressed, talk dirty to me," is appalling to the state. And it should be appalling to this court. And it demonstrates that she has absolved herself of any responsibility in this and not taken responsibility for the consequences and the weight and the gravity of her actions. It should be really clear to her at this stage what she did and what the weight of that is. And instead, she continues to behave like that. She continues to behave in a way that demonstrates she doesn't get it. She doesn't appreciate what she has done. But just because she has absolved herself of responsibility in this by saying it was her mental illness, doesn't mean that the court has to absolve her of that responsibility, nor the law. As we sit here during the course of this trial, 4 years later, when she is perfectly stable and perfectly medicated, she continues to demonstrate a callous indifference for the actions that she caused and for the loss of that baby's life. And that is why the state is recommending a sentence of life without the possibility of parole. Because as we sit here now, she continues to demonstrate that calloused indifference and that complete disregard for the life of that child that should be given the utmost respect. And instead, a bunch of strangers from Cherokee County had to be the ones to compassionately extend our hearts to that baby.
Ms. Trethewey, does the defense have any dispute about the facts stated by Ms. Grover?
We absolutely,
As far as
we do. And I'm going to preface this by saying I think it's pretty petty at this point, since we were served these at 4:30 yesterday afternoon with respect to this particular incident. They have absolutely no relevance to why we're here today whatsoever. The state can acknowledge, and I don't think they would disagree with me, that there are thousands of phone calls and chirps and text messages, including ones with that gentleman right there, that indicate that she was remorseful, that she was upset about what happened. There are phone calls, hours worth of phone calls of her crying on the phone, talking about what happened. The fact that she was talking, well, I'll say that she was talking to this individual on the phone for months leading up to trial. State has those phone calls. They serve those on us. She didn't talk about the case at that particular point in time because that's what she was instructed to do. She wasn't talking about the facts of this case. She wasn't telling this gentleman that she was getting away with anything or doing anything. She was not talking about the case because that's what she was instructed to do so. She is allowed to talk to people. She did so at the jail. She didn't talk about the case because that's what we told her not to do. The fact that she didn't say, oh, I'm upset about what happened at trial today, or I'm upset about what happened to Hannah on these phone calls, it has nothing to do with whether or not she was remorseful. And I'm going to say this, and I've kept my mouth shut about this for a very long time. I have an email from Ms. Crawford from February of 2023. Ms. Crawford and the district attorney's office sought out us to sit down and talk to Ms. Driver at the jail in an attempt to work this case out. I take issue with the assertion by the state that we categorically rejected the felony murder, guilty but mentally ill, life with parole option. What we have always strived for in this case was a reduction in the charge that appropriately reflected the mitigation that Ms. Driver suffered, the mental illness aspect of it, but I'll also go back to this email. This was at the request of the state to sit down and talk to Ms. Driver at the jail. This was also at a time where the district attorney's office was well aware that there had been communication for a very long period of time with Mr. Ben-Michaeil at the jail. In that email, the purpose of this case, the meeting, was to determine what information Ms. Driver possessed about the criminal culpability of Benyamin Ben-Michaeil, aka Brian Joyce, which could be presented at a proper under oath under any potential plea of guilty that she may enter. The way that Ms. Crawford is categorizing the plea negotiations in this case are inaccurate. The state, during that meeting, Ms. Driver told the district attorney's office and myself she was continuing to contact Mr. Ben-Michaeil, provided them information that they didn't previously have, which subsequently led to the discovery of a bunch of other phone calls. Ms. Driver told them that. She was honest with them about it. What the state is not talking about here is the suicide aspect that was involved in this case, that the state was looking at this from all angles with the other people's involvement in terms of criminal culpability, but also with regards to her mental health. That has always been what this case is about. She exercised her right to trial because she has the right to do that. She exercised her right to trial because the state of Georgia, despite these plea negotiations and the evidence in front of them, did not want to recognize the mental health aspect and what we were asking for in terms of a lesser charge. Ms. Driver exercised her right to trial to show this world what that gentleman is like, what life with him is like, to put before this world that she is not the only victim of this person, and that in an attempt that maybe other people will be aware of what this involves. She has always accepted responsibility for the actions. We saw it at the hospital. We saw it with Detective Cruz. We've seen it in subsequent interviews with the expert. She has never denied what happened. She's never denied what she did and what she did to herself. And she understands what needs to be happen. At this point in time, Judge, the fact that she's talking to another individual is irrelevant. She's allowed to do that. They're not talking to you about any other phone calls where she may be talking to her parents about what happened. There are plenty of phone calls where she's on the phone with her mom and her dad, hysterical in tears about what happened and knowing what it did to them and to everybody else that is affected by this.
The state has the right to conclude. Anything else that you wanted to say, Ms. Crocker? And then I'll let y'all approach the lectern, and I'll hear from
I would
Ms.
just like
Driver.
to say that the defense's stated objection with regard to all of the sexting she was doing during the trial was relevance, not dispute as to whether it occurred. The state served all of those on the defense. It didn't find it necessary to read every disgusting message into the record, but the state's position is that her general moral character is admissible at a pre-sentence hearing, so it is relevant, and it also demonstrates a lack of remorse in terms of the timing and the context of when those messages occurred in relation to the days we were watching her daughter die on video and reviewing the autopsy photographs. That is the reason the state brought that information before you. So I would just like to make that clear.
All right, Ms. Trethewey, and Mr. Kessler, if you want to approach as well. Ms. Driver, you can come to the lectern and make any kind of statement that you'd like to. If you will place her under oath, please.
Want me here? Yes, I will. Okay. All right, Chloe, for the first thing I'm going to have you do is I'm going to have you raise your right hand. Do you swear the information testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. You're going to have to speak up. I know that you're fairly soft-spoken, so were you able to get that? All right, go ahead.
I appreciate the opportunity to be heard during this whole process. I am terribly sorry for many things in my life, but most of all for who was lost, and I always will be. Every single day I live with my guilt. I have drowned in sorrow and regret with such an acute awareness of it for so long, I never imagined there would be anything more than that for me. Quite frankly, I didn't believe I deserved anything more than just that. In the past, I genuinely believed I had to die every day for my daughter, to hate myself for my failure in protecting her. But I know now that life goes on whether I suffer or not, so I need to stop taking from it. I know now that I must live for my daughter instead and do the best I can to be kind and loving and giving, because that's exactly what being with Hannah taught me. I see her everywhere, in everything. She lives on and shows me that beauty can be found anywhere, even where I'm going, because I can feel her in my tears. I feel her in my friend's embrace. I see her in a stranger's kindness, in someone's undiluted joy at seeing their loved one. I hear her in people's laughter, and I know her most of all in my family's loyal love for me, even still. No matter how bad our losses, life can be good again, and this is not my end. I accept my punishment with peace, and I want it to be known for every person that has prayed for me, that our Father has heard you, and I have been given a contentment that the world cannot take away. My daughter's memory rests now, so I am able to as well. I want it to be said that no one ever plans to lose control of their own mind. This trial was only a snapshot of my life and mind. It's easy to review the past and say what could have been done differently. It's even easier to say what someone should have done. But that's just it. In the midst of a terrifying situation, you can't actually think. The horror and fear you feel clouds your thinking abilities and disconnects you from reality. So though I may not legally meet the definition of insanity as of today, I know in the bottom of my heart that I was, because I never would have done what I did had it not been for my decompensation. In the end, we can't go back and undo the bad, no matter how much we want to, but we can learn from it and prevent it from happening again. I will continue to seek help for my mental illness because of this. I read once that suffering is cheap as clay and twice as common. What matters, though, is what each man makes of it, and I promise I will make the best of whatever you give me, Your Honor. Thank you.
y'all stay. Yes. I have continued to think about this case after the verdict, as I am sure all of us have. I have been aware that based on the law, that my only real discretion in this case is whether to sentence you to life without parole or life with the possibility of parole. I am aware, as Ms. Trethewey pointed out, that the parole eligibility in this state would dictate that you would serve 30 years of a life sentence before you were considered for parole. This was a heinous offense with evidence that was so graphic and traumatic that I began to do research on what kind of support and help we could give the jurors who were having to consider it. A parent killing a child is something that just offends us on the deepest level. It is a wrong that just is unfathomable. It just cannot be understood. And it scares us because it is so contrary to just fundamental moral behavior and what we expect of the bonds between human beings. And I have all those thoughts. I have had all those thoughts in this case. I noticed throughout the trial and considered it as part of the tragedy, quite honestly, that there were really no family members here to support you, and that Mr. Ben-Michaeil was not here interested in the outcome of what was going to happen to his child, the person who killed his child. That was a very interesting dynamic to me. So I'm glad to see him here today. You don't need to speak to me at this point, sir. Your opportunity to speak has come and gone. Although the response I just heard doesn't do anything to make the whole situation any less tragic. But as I said, I'm glad to have heard from Mr. Ben-Michaeil and to honestly try to give him some benefit of the doubt, understanding that there is an impact on him that cannot be measured, as he put it, and just again an impact on the universe. One more child who never goes to school, never gets to have a boyfriend or go to the prom, never gets to decide what a career is. They're not words to talk about what a terrible thing it is. But I do also feel bound to consider the fact that if you had succeeded, we would not have been here. We would have read about a tragic, inexplicable murder-suicide. I have to take into account that 3 different psychologists testified as to your profound mental illness, the depths of your sickness, your illness. I have to take into account the fact that the jury found you guilty but mentally ill, because they obviously were aware they had the choice of imposing a different sentence. I sent a different verdict, I'm sorry, a verdict of guilty that did not reference any of your mental illness. Georgia law, Georgia statute means that the guilty but mentally ill verdict gives the Department of Corrections some direction and some ability to continue to provide treatment for you, but that is in their discretion. There's no black and white law as to how a judge is to consider that verdict. I will note that the jury found that you did not meet the criteria of not guilty by reason of insanity. The law in Georgia has been the same for about 200 years now. Whether or not that ever changes because of changes in medical and societal understanding of mental illness and how to treat it, I do not know. The intersection between law and medicine can be, well, it does not always mesh well. Things evolve. We now have treatment courts for people with mental illness and addiction, substance use issues, and the law and the courts slowly come about in proper cases to figure out about treatment. I don't quarrel with the jury's verdict. I don't impose this sentence out of sympathy. But I do think under everything that I heard, the sentence needs to take into account the possibility that in 30 years, there may be different treatment modalities, different recommendations, different possibilities for your rehabilitation. I think the notion that you are cured because you're taking medication regularly now is something that I don't accept. I believe everyone acknowledges that, or at least based on the law and the testimony we heard in this case, that borderline personality disorder, for example, is a deep sickness that is not treated just by medication, for example. You were treated in order for you to gain competency to be able to actually go to trial. I don't think anybody who's dealt with anybody with mental illness is naive enough to suggest that you're cured. And I know I don't mean that as a criticism or a punishment. It's just reality. You did a horrible thing. But based on the evidence at trial and based on particularly the mental health testimony, the court will impose the following sentence as to count 1, malice murder, life in prison with the possibility of parole. Count 2 and count 3 are vacated as a matter of law in that you cannot be sentenced to more than one murder count when there is only one victim. Count 4 merges into count 1. I agree with the state that count 5 does not merge into count 1 as it contains a different element, that is that the victim is a child under the age of 18. That is not an element of malice murder specifically. So as to count 5, the court imposes a sentence of 20 years to serve in the state prison system concurrent with count 1. You have a right to appeal this conviction. You have a right to file a motion for new trial requesting other post-judgment relief. You must file any such notice of appeal or motion for new trial within 30 days of sentencing. You are entitled to have a lawyer represent you, and if you cannot afford to hire one will be appointed to represent you. I know Ms. Trethewey and Mr. Kessler are familiar with the procedures of our Indigent Defense Office as to how new counsel would be appointed to represent you moving forward. I would request that that the counsel, if you will remain with us, and we will keep Ms. Driver, we can keep her here to get the minutes prepared, reviewed, signed, and get that taken care of before Ms. Driver is taken away from the jail, or the holding cell. Yes. All right. Thank you all.
Thank you.